First of all, thank you, Menashe, for inviting me to moderate this session. It's always a pleasure to work with you and the Institute, and I look forward to more to come. First of all, before we start on the substance, I would like, because this is a very big panel and we need to contain the timing, first of all, I would like to ask our guests to introduce themselves really in 2 sentences, not more. And second, I already send out, because Menashe is really scary. And if I will not abide to the timing, if we will not abide to the timing, he will take action. And I want to avoid that. So I will be more assertive on timing. So let's start with Natasha.
Good morning. A pleasure to be here, especially as I can introduce myself as being 8th generation in the land of Israel, I hope. But I'm a barrister based in London at Sixth Pump Court Chambers, and prior to that had some experience of international arbitration at Skadden Arps, which is where I trained as a solicitor.
Noah Rubins, partner at Freshfields in Paris.
Gideon Fisher. I chair the Israeli Arbitration Forum at the Israeli Bar, and it's a great opportunity to convey the greetings and gratitude of the president of the Israeli Bar to all of you, whether you're from overseas or local. I am an ex-judge within the ICC Arbitration Court on behalf of the State of Israel. I have my PhD at international arbitration, probably the only one in Israel who has a PhD here at Bar-Ilan University. And being Israeli born and bred, all my legal education is from overseas. Cambridge University, I'm the president of Cambridge alumni here in Israel. I studied with Professor Roger Fisher at Harvard University at the program of Getting to Yes. And most of everything, I would say that ever so privileged to be here at this amazing gathering, because for me it's a dream come true. So thank you very much.
Good morning. I'm Matt Slater with Cleary Gottlieb in Washington, D.C., not New York. I've got 35 years in practice of international litigation and arbitration. I'm now a senior counsel, which means that I'm relieved of client responsibility and will give me the opportunity to serve as arbitrator and mediator in disputes, hopefully including disputes that are either seated or have their venue in Israel.
Good morning, everyone. My name is Anton Asoskov. I've been a professor for 25 years in the leading Russian university. I've made my aliyah to Israel in 2022. And I continue to act as an expert and arbitrator in Russia-related disputes. Thank you for inviting to this panel.
Daphna Kapeliuk, partner at Goldfarb.
Thank you very much, all. So with that, the topic of the session is promoting Israel as a hub for arbitration. And when thinking about the topic, we discuss a few elements of what we consider to be requirements to transform Israel into an hub of arbitration. And what we intend to do is discuss each element, present the Israeli perspective, present the international perspective, and try to see if we can A, agree, which the answer is no, and B, whether we can have some ideas, some thoughts, and some answers maybe about what the future brings. So we will start with the issue of government support. And these questions go to Daphna and to Natasha. So we'll start with you, Daphna. In the past, and you and I know that participating in international arbitration conferences throughout the years here, there was always a discussion about modernizing the law. Always a discussion about let's adopt the UNCITRAL model, let's adopt the UNCITRAL model. Is this enough? Is this sufficient?
Well, I think that the adoption of the law, and as it was mentioned before, it was done during the war. It was something that there was no discussion or no dispute between the different parties in our parliament, is an extremely important move towards the internationalization of arbitration in Israel and the recognition of Israel as as maybe as a place or an important place or even a hub for international arbitration. But this is not enough. And I think we have great lawyers, we have great law firms with extremely educated in international arbitration teams who actually handles extremely complex international disputes in many arbitral institutions abroad, but this is still not enough. And I think that the main issue here is our courts, our court system, who throughout the years have shown an interesting view towards arbitration, towards international arbitration. Noah yesterday spoke about the New York Convention, Article 2.3 of the New York Convention. Israeli courts have interpreted it in a particular, I say, interesting way, giving way for courts for more discretion than in other courts if we do a comparative analysis. And I think that if the courts do internalize that they have to have a uniform approach towards international arbitration, as in other countries who have adopted the UNCITRAL model law, that have adopted the UNCITRAL model laws, but also that are parties to the New York Convention, then we may see a huge development here and a step towards Israel becoming a hub in international arbitration.
Thank you, Daphna. Natasha, England recently adopted a new arbitration act. And in Israel, we always complain that we have a very old act. So in England, the old act was 96, and the new act is 25. And the question for you, was London's position as a favorite hub one of the issues that was considered when first considering amending the Arbitration Act in England? And second, did the different amendments that were made to the law in 2025 were meant to address also issues of making London a favorable hub for arbitration?
They certainly were. Perhaps the first clarification, though, that I should offer is this is an arbitration act for England and Wales. We mustn't forget the Welsh. But there was a law commission review of arbitration in the UK and a real desire to keep London as, one of the premier, if not the premier, arbitration seat available. In the UK generally, we have a sense that English law remains one of our best exports. English law and the best traditions of the English bar. And there was a real sense that that 1996 Act needed to be updated to be able to reaffirm London especially as a leading place for arbitration, the stability, certainty, predictability, and allowing as much autonomy as possible for the parties, ensuring that the commercial court assists that with that framework, with that support. And there are 5, in my less than 5 minutes, very brief key changes that I thought it would be helpful to highlight, because I know that so many in Israel are thinking about the best way to emulate these sorts of provisions in the environment. The first, perhaps I think the most significant, is in relation to the governing law, which has been made that of the seat of the arbitration, and that clarifies the position significantly after the case of Unicredit Bank. And the idea there, of course, is to create legal certainty and ensure that the parties are able to opt out of this. This is the default, but in the absence of there being a clear indication as to governing law, it will be the seat from now on. The second is in relation to summary dismissal, and the idea here is to provide an avenue to reduce the cost and delay of claims that really do not have a prospect of success. So the case here is no real prospect of succeeding. That's the test that can be applied. And in this instance, the Act doesn't prescribe specific procedures, but it leaves it to the tribunal's discretion in consultation with the parties. And again, that's all about ensuring maximum flexibility. Third is in relation to the powers of emergency arbitrators. The grant of emergency powers explicitly here, express powers, is a change. Clause 8 of the 2025 Act extends the enforcement mechanisms that exist, that have been available to regular arbitrators in the context of emergency arbitrators, and that's clarifying, I think importantly, where you don't have a fully constituted tribunal, that you can still make use, and these powers will be enforced by the courts if necessary. Fourth is the duty of disclosure, and the importance here is in relation to impartiality. So the Halliburton and Chubb case, which kept us all busy for so long, was critical to this effort to codify what the case law had outlined. And importantly here, it specifies that an arbitrator must disclose not only what they actually know, but what they ought reasonably to be aware of. So there is a positive obligation to ensure that due diligence is conducted. And then finally, there are a few others, but I'll leave that to questions perhaps. But finally, arbitrator immunity. The Act extends arbitrator immunity, in particular protecting them where they resign or are subject to removal applications, which are, unless of course bad faith is involved. And that reform was seen as necessary to prevent arbitrators from being unfairly penalised for stepping down on the basis of good faith, so they can withdraw now without fear. And in each of these instances, making England and Wales arbitration friendly and ensuring that reputation for being, the centre of the world as far as arbitration is concerned was paramount. It strikes me that there are definitely important lessons that can be learned for other jurisdictions, in particular with Israel as a seat, and that support mechanism by the courts is continued to be considered critical to ensuring that London is a decent choice.
Thank you very much, Natasha. And this actually brings us back to Daphna for our next question. And Natasha finished her remarks with a notion that the courts and the court system should help the parties and should help promote, in that case, London and England as a seat for arbitration. Do we need the same in Israel, and how can we achieve that?
I think it might, I think that, first of all, judges should speak English and not request many times translations of long awards to Hebrew, 400 pages award, for example. I think that would be helpful. I think it would also be helpful, but this is a long shot, if we could have a specialized court within, let's say, the district court of Tel Aviv, with a few judges who understand international arbitration and could promote that. I think that would be a great step forward.
Thank you very much, Daphna. So with that, I think we will put the government support issue aside, and we'll move to a second topic that we discussed, and that is the rejection of local protectionism. And with that, I will start with Gideon. Gideon, currently, under the black letter of the law regulations in Israel, foreign lawyers are not allowed to represent clients in Israel in Israeli law matters. How does that apply to international arbitration?
Well, the good news that I started with the greetings from the president of the Israeli bar, which means that the bar is aware of what you are saying, Shai, and this is under examination. I cannot tell you right now that that within few months there will be a massive change, but the truth of the matter is that Israel would like to become, as Menashe and Uriel said it before, a hub for international arbitration, just like many other capitals around the world or many other big cities around the world. And in order to do so, it will be wise for Israel to adapt and adjust and allow and enable foreign lawyers to be here in Israel not only as arbitrators, because this is obvious that they can do right now. Any of this distinguished panel can be an arbitrator in Israel, and this is absolutely acceptable, no problem whatsoever. But if you guys or ladies would like to be also litigators, this is a bit more problematic as it stands right now. And I see a nice change with the fact that the Ministry of Justice, alongside the Israeli bar, are working with me on this process. And I can tell you that here in the audience, I can see international arbitrators who have just been qualified, just Israeli lawyers, by special program headed by Judge Meltzer and other distinguished judges. I came up with this plan in order to bring the good news to Israel. It's not just that we have a new law, 2024, a new law of the International Commercial Arbitration Act, but we also want Israeli lawyers to have the knowledge and to become international arbitrators. So we are doing the training together with the Ministry of Justice. And parallelly, we would like to have foreign lawyers here in Israel enjoying the privilege of litigating here. And I'm quite confident that we will have further plausible changes in this matter. And just the last sentence, as I cannot just finish this preamble without thanking you, Shai, because nobody, I mean, we all listen to you as a moderator, but I think that you, Shai, together with Roy over here from Herzog, Yuval Naim, many others who are doing amazing job enabling and getting this process ahead. So it's a big thank you, Shai, and all the rest here who are doing an excellent job. Thank you.
Thank you, Gideon. Matt, moving to you now, because in California, in the US, you had pretty much the same issue, although I would say, I would believe that the implementation was a bit different. And although California seems like an ideally placed hub for international arbitration, in the past, lawyers who were not admitted in the US or in California were unable to act as counsel in arbitration seated in California. Do you believe, first of all, if that situation impaired California's ability to get ahead as a hub? And second, that was changed a few years ago, about 7, 8 years ago. Do you see the impact of that change on arbitration, international arbitration in the US?
So I would say that for sure, the impediment to non-California lawyers representing parties in arbitration in California was an impediment to the development of California as a center for arbitration in general, international arbitration in particular. And let me just place that in a little bit of context. So when parties are considering where they will seat their arbitration or even conduct their arbitration, they look to the reputation of that location for neutrality and impartiality, for the ability of its courts to support arbitration and not arbitrarily intervene in arbitration, and for the ability of the system, the court system there to both enforce agreements to arbitrate and enforce awards that result from arbitration. California failed in that regard in a decision by its Supreme Court in 1998 that said that non-California lawyers who appear on behalf of parties in arbitration in California are committing the unauthorized practice of law in California. The legislature quickly intervened, and as of 1999, it was possible for out-of-state lawyers, but still members of the bar of another state in the United States, to represent parties in California, although I will say it was subject to a fairly onerous process. Only in 2019 did California adopt a law that allowed parties to have counsel of their choice in international commercial arbitration taking place in California. And the strictures associated with that are not as onerous as for those in domestic arbitration, but nonetheless, they were late in coming. And I think that that delay had a significant impact on California as a place for arbitration. If I can, for a moment, interject myself in the first debate, California, during that same time period, gained a reputation in its domestic law as being hostile to arbitration. There were a large number of cases that came from California, either at Supreme Court or from the Ninth Circuit U.S. Court of Appeals, adopting or applying California law that were viewed as being hostile to arbitration, both domestic and to that extent also international, consistently reversed by the U.S. Supreme Court. And I think that those two things in combination impeded California's development as a center. It's trying to make up the ground now. There is something called the Silicon Valley Arbitration and Mediation Center, which is trying to promote Northern California in particular as a hub for technology arbitration. I think that you should be aware of that, because that's an area where Israel can compete quite substantially and successfully. But you want to be sure that the legal environment, both as to the ability to select counsel and the support of the courts, is here so that you can succeed in that endeavor. And if I can, for one last second, agree with our introductory speakers about the desirability of promoting Israel as a place for arbitration. I would draw a distinction between seat and place to conduct proceedings. Both are important, and those of us from outside of Israel have a role to play there too, in letting people know of our experience, both with counsel and with Israel as a place to conduct business, so that we can suggest it as either a seat or a place based on our own experience going forward.
Thank you very much, Matt, for those enlightening words. So I think with that, because I had a follow-up question for you about whether we should change the position in Israel, but you already said you are working on that. So I assume by that you are in favor of changing that.
Not only that, I will tell everybody a big secret. Seriously, a very, very happy thing that not many people know. The most important convention on international arbitration worldwide is obviously the New York 1958 convention. All the countries in the world have signed it. The very first country that signed it is Israel. So this I brought forward to the Minister of Justice, that we have to be at the edge and basically the pioneers in this matter, and take this to enable counsels from overseas to be here. So I'm optimistic.
Thank you, Gideon. So now we will move forward to the third element we discussed, which is innovation. And I would like to start with you, Noah, because I know that you have a slightly different views than I would say mine and some of the other people I've talked to. Do you believe?
No doubt on any number of topics.
Yeah, I know that.
You like the debate. You like the debate.
But you made during a prep call, an interesting comment, and my question to you on that was, do you believe that innovation is even a requirement for making Israel or transforming Israel into an international hub? And if not, do you think it's relevant at all to any jurisdictions who want to promote themselves? And I'll put this in a bit of context, and then for those of us who are in the arbitration, the arbitration conference circuit, we hear a lot about new developments in Singapore, new developments in Bahrain, new developments in Dubai, the Saudis, et cetera, and we always hear that these innovations are helping, assisting those hubs to transform into desired arbitration seats. And I would like to get your view on that.
Sure, thanks. We in the arbitration community, and I really shouldn't, I don't really mean lawyers, I mean the users of arbitration, business people, are in the business of predictability, right? To the extent it's possible. They deal in risk, but they want to quantify risk. And that goes as much for a dispute resolution clause as for any other clause in their contract, right? They need to know how much does it cost? How much am I going to pay for this deal, including everything, including a potential dispute. I don't know what it's going to be like. I don't know if I'm claimant or respondent, behind the veil of ignorance. I need to know from a broad perspective, what am I buying? What am I selling? How much should it cost? That's really it. Everything else is sort of little bumps on the sphere of the deal, okay? And therefore, from that perspective, anything that is done by the seat of an arbitration, by the government authorities, by the courts, which is unpredictable, unexpected, is negative. It makes it more costly, not less costly. Therefore, when compared to other seats, I'm not going to do it. I'm not going to take that because it's more expensive for me. Unless I have an emotional attachment, right? I have an emotional attachment to Israel. Therefore, I say, I am insisting. I'm willing to pay extra, right? Could be, not usually, but could be. So, really, what the courts and the arbitration community that wants to transform Israel into a regional hub for arbitration, into a preferred seat, should be doing is thinking on the classical liberal ideal. How does the government get out of the way and allow the paths of normal commerce and normal economic activity take their course in a way that, behind the veil of ignorance, the participants would have expected it would go? Now, I want to tell you another parable. I like parables. I like midrash, right? I told a midrash yesterday. I'll tell another midrash today. It has to do with France, the country where I've lived for the last 22 years, okay? And in France, they looked at this process in England and they said, boy, oh boy, they're up in England, they're stealing our lunch. You know, we used to be the number one seat for arbitration, and now every poll shows that London is ahead of the game. All right? And now they're revising the 96 Act. We've got to revise our Act too. Now, keep in mind, the French were the original pro-arbitration jurisdiction. In some particular ways, there is no jurisdiction in the world as pro-arbitration, particularly on the enforcement of arbitral awards. On its face, there is no place that will protect an arbitral award the way that France will. But we got to change. We've got to innovate. Look at Singapore. And so he'll remain nameless, but there is a very famous lawyer who decided, I want my name on an act, I'm going to do this. And unlike in England, where it was a consultative process over 2.5 years, we were all involved. I was also involved in the process. We were all allowed to give our ideas as to how England can be, England and Wales, excuse me, I don't want to forget the Welsh, England and Wales can remain the same. This, the French Act has not yet been amended, but it will be, because it's top down. And the bells and whistles, you will see it when it comes, the bells and whistles have nothing to do with the true problems of arbitration in France. The idea that you can bounce up and down between the Court of Appeal and the Court of Cassation for 4.5 years, Rusoro against Venezuela, one of my cases, has been there 4.5 years, and we still don't know when it will end. That needed to be fixed, not the bells and whistles, the innovation and so on. So my advice is, don't focus on innovation. Innovation, particularly in Israel, will come, but it will come because the users of arbitration will say, hey, let's do this, and they will create it. You don't need the state to create it. You don't need the judges to create it. What you need is to provide the space, as has always been here in Israel, to innovate on a private basis so that people can tailor their disputes, conduct them in the way that they would expect.
Thank you. I think we'll agree to disagree a bit because we can speak about innovation as a notion, or whether the state should innovate, or the court should innovate, or the private institutions should innovate. Innovation in it by itself, I don't think refers only to the state, because I would say that the problem with the state innovating or the courts innovating, it's that those innovations are done after the arbitration agreement, sometimes after the dispute arises. When the institutions innovate, they will usually, and I say usually very carefully, because sometimes in agreement we adopt an arbitration clause that refers to the arbitration rules as they will be amended from time to time. But usually we refer to specific rules which we are familiar with. So any innovation coming from the Institute is already embedded and is already part of the bumps. We will get back to that, but I want to.
But let me just finish off the idea on that basis. Look, innovation is also innovation that will lead to Israel as a seat of arbitration. That's not going to come from the arbitral institution here. Okay, that's the next step. It comes from people choosing ICC Tel Aviv, LCIA Tel Aviv. Why not? Right? AAA Tel Aviv. That's how you become a hub. Not because people go like, I'm going to arbitrate in Israel because there's an arbitration institute that has wonderful rules that are very innovative. Because they can also choose those same rules and have a seat in Dubai. Why not? Of course they can. Right? And so I'm just saying, innovation that's going to change the scenery here, it's not innovation. That's all great stuff and people will do it, but it's not connected to Israel as a place of arbitration.
Okay. But with that, I will ask, but with that I will ask Anton to take the opposite view. And the question to Anton on that is, Noah spoke about the end users, and so the question is double. First of all, whether in your belief the end users are looking for innovation and are looking for different ways or different routes to resolve their disputes in arbitration, and B, which end users should Israel target in that attempt to become a hub? Whether do we only need to target, as Noah mentioned, and I know I'm generalizing on your comment, and it's made it with a specific purpose of the users of the major institutions. Do we need only to target ICC users, LCAA users, AAA users, SIAC users, and promote only the SIT, or do we want to sell or give them more options and try to target more sophisticated players or different players in that sphere?
Yeah. Thank you very much, Shai. I agree with what Noah said, that the focus should be on the end users. At the same time, I think we should not discuss innovation in general, in abstract. So we need to discuss the expectations of the particular groups of end users, and I'm afraid they may be different. Why we should not discuss innovation in general? I agree here with Noah, actually, that when we talk about, for example, innovation in arbitration rules of different institutions, we see that very rapidly all such legal innovations, if they are successful, they are copied by other institutions. So we have all these examples with consolidation or joint of a third party, emergency arbitrator, expedited rules. So we know that every such a successful innovation will be rapidly taken on board by your competitors. And even more so, I also agree with Noah that most groups of end users, they do not care a lot about legal nuances. And I will give you an example. So I've been a member of the governing body of the Hong Kong International Arbitration Center for 6 years. And there is an interesting feature in Hong Kong and in Singapore, and it deals with quite a sensitive issue of arbitration fee, that you can choose the methods of calculating the fee. So by default, these are hourly rates, but the end users can opt in ad valorem system, so when the arbitration fee is calculated depending on the amount in dispute. And what is interesting, and maybe it's not economically rational, but even if you see that the end users, they are entering into small or medium-sized contracts, and it's more than rational for them to opt in the ad valorem system, so to go away from the hourly rates. But the statistics, for example, of the Hong Kong Institute shows that it's done very rarely, so from 10 to 15%. So this confirms that all these bells and whistles, how Noah called it, maybe it's not the focus. And you've asked me what can be the focus group for Israeli arbitration. And here I can use my expertise as a Russian lawyer. So I think that Russia-related disputes, they are certainly the one which could be in the focus. I think all you know that there was, and it's continuing, a radical shift in the way how Russian businesses structure their arbitration agreements. So before 2022, mostly disputes went to London or to some European centers like Paris or Stockholm. But after introduction of this wave of sanctions, we see the radical shift to the east, and here Israel can position itself as a neutral and interesting venue for Russian clients. But what Russians care about, of course you understand, they care about sanctions. So if the relevant jurisdiction and the relevant institution can propose the way how the Russian end users can decide all these problems with paying arbitration fees, with hiring local counsel, then it will be a very good selling point for the Russian clients. And we've heard today from the Honorable Deputy Chairman of the Supreme Court that Israeli are smart enough in order to resolve this issue. I hope so. just a suggestion of what can be made. In Russia, there is an interesting approach to arbitral institutions that they need to obtain a kind of a license from the Russian government. Not only domestic Russian institutions, but also foreign institutions. And up until today, there are only 5 foreign institutions who are licensed by the Russian Ministry of Justice. And none of them have a branch in Russia. So none of them have, I don't know, bank accounts in Russian banks and propose some solutions for sanctions Russian entity. Maybe, I don't know, I'm just brainstorming, but if Israeli arbitral institution is brave enough to be the first to obtain this license and to open a branch in Russia, that will be a very creative move to attract Russian end users. Thank you.
Thank you, Anton. That is actually very, very interesting. So I would like Menashe now to intervene in our session. Do you want to comment?
Yeah, I can tell you that we already started the process, and we're in the process of, we have submitted an application that the ICA would be, we have a branch in Moscow in Russia. Yeah.
Thank you. Interesting.
Just apropos of that, I'm aware of a number of arbitrations with the SIAC arbitrations with Singapore as the seat, but being conducted in Dubai. And that's what I was saying before. Think about where proceedings could take place. They're Russian related, more convenient to go to Dubai, but they wanted the certainty of that particular regime. You could do the same here.
So I fully agree with you, Matt, on that as well. I had the pleasure of doing that competition of the venues, not the seats even, in a particular arbitration that I was chairing. And we gave the parties 3 options, Istanbul, Dubai, and Israel. And I of course didn't want to travel for the hearing, and it was very easy for me to conduct it in Tel Aviv. So I proposed Tel Aviv, and this, I don't know whether we have anyone from government in place, but the answer is that Tel Aviv is problematic because it would be difficult to obtain a visa for the expert witnesses to come over to appear in the arbitration. So again, there's a lot of red tape to cut, but I fully agree. Yeah, that's part, I think, of what we started with the governmental assistance that we need in order to streamline the process.
You could even imagine a special visa. I mean, for example, Washington is the seat for ICSID arbitration, right? Which there is no legal seat to ICSID arbitration, but the default venue is in Washington. And there's provisions in the Washington Convention which ensure safe passage for people involved in the arbitration, including the arbitrators and experts and witnesses and stuff like that. And so that's been envisaged. It's particularly important, right? And you could imagine a special visa regime.
And also, if I may add, I'm conducting now a AAA in Miami, international arbitration in Miami, and not the lawyer, the counsel, but rather the arbitrator from Ecuador was not granted a visa to the United States. And it was hilarious, but it was a tragic matter. So we ended up in a video conference arbitration. So nowadays, with the video conference, everything can go.
It's not just Ecuador. I had a case in the United States, seated in the United States. One of the arbitrators was Canadian, but a very famous Canadian arbitrator who was on a watch list because of some public statement that he had made. I don't even remember what it was about. I think it was connected with Iran. That he had done some business with Iran or something like that, which Canadians can do. I mean, there's nothing wrong with Canadians doing that, but...
Up to the age of President Trump.
No, I'm sorry. No, I don't buy that. No, this was ages ago, and the extraterritorial sanctions, right? So it didn't matter. So we ended up going to Vancouver, and so the United States policy on is much more important than that sort of thing than arbitration. Well,
And Vancouver is lovely, so it's good.
So we had another topic to address, but I don't think we have time left because I wanted to leave 5 minutes for questions from the audience. So are there any questions? Kathleen?
So I've thought about this topic a lot for another relatively new arbitration institute in the Middle East. And I think that what's important to think about is to, as you said, Noah, decouple, I believe you said, somebody said, to decouple, maybe it was you, Matt, decouple the rules from the venue and potentially the venue, the seat and potentially the seat from the venue. But if you're looking at seat, I really, other than potentially with a relatively special issue like sanctions, the question is, will my award be enforced? Will my award, be recognized? That you can repeat that over and over again, and that's really the issue. And I thought, actually, supporting whoever, I guess it was Noah, who was not such a fan of innovation, that the really smart thing that Israel did was just adopt the UNCITRAL model law, which I remember talking to Toby Landau about in 1994 in Howard Holtzman's apartment. I said, why aren't you guys just going to adopt the model law? That would make it so much easier for you to attract international arbitration. It's worked out well for London anyway, but I still wondered, and when this new act, I said that again, and Jacomine laughed at me. She's like, Kathleen, would you shut up about that? It's been 20 years, 30 years. So I think that's one thing. The other thing is, I think London's been really effective at sort of coupling choice of law with venue, but most institutions it's not, right? So you don't go to Singapore because you want Singapore law, you go to Singapore because it's a safe seat, and then you need to decouple the institution from all of that, because what people want from an institution is efficiency, communication, safe pair of hands, which is related to the issues concerning the seat, but different, right? And so I think that if you think about it in all those different aspects, the net is maybe innovations with respect to the institution, if that's the way you want to go. But I think for everything else, it's about predictability. It's about safe seat, safe seat, safe seat. They're going to enforce my award. It's a safe seat. But I am starting to hear when I talk to folk about coming to the U.S., like why don't we do arbitration in New York, which used to be, okay, you've got a party here and there, and we'll go to New York, everybody likes it. Now it's like, no, I won't be able to get my witnesses in. And you can do the whole song and dance about how, well, it could be the venue and not the seat. They're like, why would we do that? We'll go somewhere where we believe we have a hope of getting our witnesses in. So I think I'm sort of anti-innovation with respect to this particular issue.
Okay, I agree with you to some extent, Kathleen, but no, I will present a question to you, but we don't need to debate it now. And this is something we've discussed with some of the panel members. We are talking about Israel as a potential seat for arbitration. We talked how wonderful it is to adopt the UNCITRAL model law for Israel in order to promote it as a seat for arbitration, in order to try and turn it into London, into Paris, into Zurich, into New York, into Dubai. And you note what all these jurisdictions have in common. None of them is a model law country. So the question is, if we want to be there, is the model law the right way? And I'm not saying it's not. I think that it's much, much better than the 1968 Act. But I'm not sure that the model law is the solution. And I leave it with that. I see you nodding.
I would just say that we already have a lot of criticism here in Israel. You know, Jews, they love everything that they can criticize. So I already heard that, with all due respect, Dr. Fisher, the new law is awful. And I said, what do you mean it's awful? How could it be awful? We don't even exercise it as yet. So, you know, the idea is that if lawyers do not really understand, the Israeli lawyers do not really understand what's going on, they adopt the new law as is, they don't opt out from the tribunal of three arbitrators as the golden path. And for Israelis, it's something that they're not used to. An arbitrator is an arbitrator. It's not a panel of arbitrators. And right now, the new Israeli law speaks of 3 arbitrators unless you opt out. So I'm just saying that...
But speaking as an arbitrator, I can only be joyful from that. Not
absolutely,
I wouldn't condemn that. So.
Yeah, talking about institution, trust is very important, and that's exactly what we're building these days. Trust and reputation of the institution. And enforcement is a huge issue, which we'll discuss in the second panel. Yes.
Yeah. Okay, so I think with that we will conclude, and I think we're on time, which is
great. Good job. Good job.
We become Swiss, so we're optimistic. We become Swiss.
We're still not Swiss, I'm afraid. So first of all, please give a hand to the panelists of this session.
Thank you very much.
And thank you all very much.